Good evening. My name is Andrew Hinkes. I'm a lawyer from Fort Lauderdale, Florida, and I'm here this evening, Saturday at 9 p.m. Eastern Time to talk to you about my presentation, The Passion of TheDao. I'm going to talk a little bit about the DAO, what it was supposed to be, talk about its governance failures, and talk about what future smart contract or decentralized autonomous organizations can learn from DAO, both its successes and its failures, its strengths and its weaknesses. I'd just like to start off this presentation by saying that while I'm going to talk about a lot of legal analysis, it should be understood that none of this is legal advice. This is simply my opinion based on my analysis, based on my training, and a lot of what I'm going to discuss is in fact unproven, brand new concepts that have never been brought before a court. So to understand what the DAO is, we have to build up from scratch, and there's no better place to start than with Nick Szabo. Nick Szabo in 1997 started discussing something called smart contracts. In his mind, a smart contract was a contractual clause like collateral or bonding or delineation of property rights, which can be embedded in the hardware or software we deal with in such a way as to make the breach prohibitive. And the archetypal example of a smart contract, according to Szabo, was a vending machine, which makes sense. When a person interacts with a vending machine, there's a lot of unstated contracting going on. The price that's displayed for the item desired is an advertisement of the amount of money needed to get it. The consumer puts the money in and presses a button. In response, the machine verifies there's been enough money provided and delivers the goods that are sought. Although we all understand how these devices work intuitively, there's a lot of actual contracting going on there. And Szabo went on to talk about future implementations of these smart contracts, including for auto finance. The idea being that the lessor or purchaser of the car would be able to make a payment electronically, and that if payment came due and was not provided, the car could actually be automatically disengaged or bricked. So this is the concept for smart contracts. Next, we build on top of it with Satoshi's blockchain. Now, most people who are watching this obviously are already familiar with Bitcoin. The advance that permitted Bitcoin to exist was the blockchain. Now, technically, any blockchain is just a database that adds information in timestamp blocks. But this particular blockchain provided a lot of new innovation. It provided immutability of records. That is, the records are never going to change once they're added. And it was also peer-to-peer in public. And this is the model that underlies Bitcoin and most altcoins. And this is the model that is being looked at by a lot of businesses as vehicles in which to build upon and improve existing value transfer processes. So you start with smart contracts, and then you add blockchains. And then you move to the Vitalik Buterin, who in, I believe, 2013, proposed his Ethereum concept. The Ethereum concept and project aimed to build Szabo's type of smart contracts on top of Satoshi's type of blockchains. The idea being the blockchain works for value transfer. Why not build what he calls a Turing-complete scripting language on top of it? And that is what the Ethereum project was intending to provide, a robust set of scripting tools that are built upon and can take advantage of what blockchains provide, immutability and the peer-to-peer decentralized nature, and of course, the transparency. Finally, we get to Slockit. Slockit was a small group of programmers out of Germany who initially wanted to build a decentralized autonomous bike lock. The idea being that you can use blockchain technology to not just move Bitcoins around, or in Ethereum's case, Ether, but actually use it to engage or disengage a bike lock. At some point, they pivoted and instead repurposed their software for something called the DAO. Now, the DAO, as far as anyone's able to tell, was intended to emulate a crowdfunding entity where, in typical fashion, you would have an incorporated business entity that solicits persons to invest. The authority to invest exists with an investment advisor or a stock picker, for lack of a better word, and the stock picker determines within parameters set by the offering documents within what the investment will be spent, and the investors have an expectation of return. However, in the DAO, all of these traditional structures were ripped apart and reconstituted somewhat differently. And the core contention of the DAO was we don't need to have people touching as many parts of this structure. We can have machines operating based upon code sets that are transparent actually do a lot of this work. So the structure was intended to split off certain responsibilities from people in part to code. It kind of evolved in stages. The first stage was the creation. That was the tweaking of the Slockit code, publication on the Git, and then execution against on the Ethereum blockchain. The funding stage, as I call it on the slide, was when the DAO was open to folks who would want to invest. And when I say invest, I use that in quotes because, as we're going to see, investment, while that's my word, never appears in any of the information provided by the DAO to any potential investors. The funding stage, as I call it, was a 28-day period when persons who possess Ether, that is the crypto asset provided by Ethereum's blockchain, could contribute those Ether to an Ethereum wallet. And in exchange, to use their parlance, you would create something that were called DAO tokens. And DAO token holders are the folks that I'm referring to as investors. With a DAO token, you have an object that can be traded. It's an asset. And you also have a set of powers or rights, depending on how you want to look at it. Among those powers and rights are the ability to vote on proposals. Proposals are code in English language descriptions of things for the DAO to invest in. And the methodology to obtain investment was to propose in English what you're going to do, who's going to be involved, how much Ether the project or the proposal requires from the DAO, and the benefit that's intended to flow back to the DAO or the DAO token holders. Now, there's a lot there, so let me unpack that for you. It's going to say both in English and in technical terms how it's going to interact with the DAO, meaning how it's going to draw Ether out. That code interface as to how it's going to interact with the DAO was supposed to be supervised and sort of whitelisted is the term by a group of persons called curators. The curators were intended to make sure that the English language description matches what the code said and to make sure that the code was not going to accomplish a 51% attack, which could allow somebody to functionally override the system and just drain all the Ethereum tokens, the Ether, out and functionally take the value. The proposal mechanics also provide for something called a split. A split is the way by which a DAO token holder can retrieve some of the Ethereum value that was contributed in order to cause the system to provide DAO tokens. It's a little complicated in that it requires a DAO token holder or an investor to create a split proposal, of which they are typically the only participant. They become the curator of it, meaning they're allowed to whitelist it and say it's approved. And if it's voted upon by them and them only usually, and approved, it would create a child DAO for which the proposing investor or DAO token holder is the only participant. And at that point, then the DAO token holder would be able to functionally cash in their DAO tokens and get back most of the Ethereum investment they provided. So that's what the split is. And then finally, at the bottom of the slide, you see what I call the doom. Just like the DAO lived, the DAO apparently is now in its death throes. And those death throes occurred last Friday, I believe it was the 17th at about 3 a.m. when a exploit, as I'll call it, was observed on the system. And that exploit had to do with an attacking or exploiting split that seized upon a coding error or a coding decision, depending on how you want to look at it, made in the Slockit code, which resulted in a split being able to retrieve more than the initial splitting DAO token holders' investment. And in fact, at the current valuation at the time, it was known to have retrieved about $50 million. So let's talk a little bit about what I call the DAO's Ozymandias event. And I don't just say that because I like 1800s poetry, but I say that because the lesson or the message of Ozymandias here kind of resonates. And Ozymandias is a poem by Percy Shelley that said, it talked about a great kingdom that had basically fallen into dust, and the only thing left was a monument to the great king Ozymandias. And one of the lines that I really like that I think applies here is, "Look on my works, ye mighty, and despair." The irony is that there's this great monument that talks about this great kingdom, and yet all it's surrounded by is ruins and dust. And the DAO flew quickly high, up to $205 million in USD valuation, and just as quickly fell into the kind of disrepair that the traveler in the poem found Ozymandias's statue or monument. So what happened here? I told you basically in the last slide what a split does. It lets a DAO token holder take the DAO tokens, propose a proposal that would create a new DAO, vote on it, curate it, have it be accepted, since typically that DAO token holder is the only person who's going to be participating in that split. And then a child DAO with the initial investment less the extra balance would be created. And then after, the whole process takes 48 days. But after a certain period of time, that investor or that DAO token holder would be able to recoup their monies. However, what happened in the case of the exploit is that a recursion call, which called for the DAO to be funded without decrementing or lowering the amount of money or the amount of Ethereum counted in another place, was allowed to run recursively. So the system kept pushing Ethereum from the DAO into the child DAO without stopping. And according to the exploiter, or someone claiming to be the exploiter, they stopped at about 50 million because they were unclear or unsure as to whether they'd ever be able to recoup value if they took more out. They were afraid that Ethereum would actually kind of crater and that its commercial value would go down to zero if they did so. Now, to anyone who's been paying attention to this, it should not have come as a surprise. Professor Gunstyrer, Nick Szabo, who I mentioned a couple slides ago, and many, many others in the industry had looked closely at Slocket's code and identified a number of exploits that were potentially troubling. Professor Gunstyrer actually attempted, through a project or a proposal on the DAO, to impose a moratorium, saying, look, folks, investors, DAO token holders, there are some problems here, both infrastructurally, technically, and from a governance standpoint, and we're going to talk about that a little bit as well. There are some big problems here, and we shouldn't be doing anything until we address some of the technical issues. That moratorium failed in part, I believe, because of the governance issues that it was hoping to solve. And if you look at the bottom of the slide, I've reposted some of the chat log that was maintained from the members of the Ethereum Foundation, kind of recounting what happened when they identified that this child DAO was starting to siphon off Ethereum that perhaps it shouldn't have. You'll see that at 3:10:17 seconds a.m., Vitalik Buterin confirms a request made in the chat to determine whether the attack was real or not. And what I think is really interesting is within a minute or two, there's already a discussion of what to do, what the Ethereum Foundation should do about this exploit. And that goes into a lot of other questions about whether it's appropriate for the Ethereum Foundation to do anything at all. And we're gonna touch on that again in a later slide. So why don't we talk about those governance failures that I mentioned before? When you talk about governance in an organization, it's kind of one of those buzzy words, but it's hard to really put your finger on what it means. In this circumstance, governance means how it functions and how the actors that interact with it work within its functionality. And this slide talks about what I call structural failures within the voting system. Now, if you had a voting system that incentivized rational action, you should have people who want a project or a proposal to be funded voting yes. You would have people who don't want it to be funded voting no. And the rest of the folks who determine that their votes don't accomplish anything should sit it out. Should be clear that when you create DAO tokens by exchanging Ethereum, the DAO tokens are some other asset. However, they do give the participant rights to do certain things, including voting. Now, the voting system itself contemplates and kind of incorporates prior understandings of how these systems work. I believe from BitShares and from some other experiments similarly, they found that a lot of voters don't actually mobilize and vote. So the voting quorum for the DAO is actually only 20%. And that becomes interesting in no small part because there were some disproportionate actors that could have exercised cartel power. There was one, we'll call that one person or entity, we'll call them the DAO whale, who had something along the lines of 8.8% of the total DAO tokens or functional voting shares. So with a few other larger wallets, it would have been entirely possible to have a cartel that could have on their own made quorum. I believe as of about 2 weeks ago, the top 50 wallets themselves held about 41.37% of the voting power. So cartel coordination was sort of an issue. I think it was the top 500 wallets had over 70%. So if about the top 150 had decided they wanted something to happen, they could have functionally dragged everyone else along for the ride. Now, voting has consequences beyond the determination of whether the DAO is going to fund something or not. If you vote, your value, so to speak, your value contribution is locked. Voting for a proposal prior to when it's determined whether it passes or doesn't pass, it's accepted or adopted or not, locks in your value. What it means is if you have already voted on a proposal, you cannot split to try to reclaim your Ether contribution less its extra balance. So voting creates some very interesting incentives. If you vote no, you're potentially locked in for a transaction that you don't want the DAO to do. Then there's all sorts of other ideas and observations about strategic voting that Professor Gunsayer talked about in length in some papers that he rushed out in the interval between this thing going live and this thing crashing, all of which were prescient and interesting. They talked about trying to do things to drive down the exchange value of DAO tokens on the exchange markets like Poloniex and other markets. And he talked about people wanting to game the system in order to profit off shorts and other options that they had purchased against the DAO tokens on exchanges. And it actually appears that those things actually did happen. And then finally, you've got human vulnerabilities, and that is you have people voting, which, like I said, suggests cartelism, and you also have curators who are intended to prevent certain gatekeeping functions. Not to cast aspersions on anyone, but it was hypothetically possible for those curators to act in conjunction with malicious actors to allow things to go through that perhaps should not have based on what curators are supposed to do. So we also had some other governance failures on the legal side that I'll talk about a little bit in further depth later on. And that is we have an unincorporated entity that's constituted by a whole bunch of people providing different functions. We're going to go into what the disclosures and disclaimers and waivers were, but spoiler alert, they were kind of a mess. And that's an interesting issue for analysis by lawyers because there are some perhaps novel issues here. The relationship between the DAO token holders and the DAO is unknown. The DAO, for all intents and purposes, is a set of code that operates on an Ethereum wallet. And does it have agency? Does it have legal standing to act? It's not clear. Do the DAO token holders or the investors have derivative standing to act? It's also not clear. Standing itself means that you are the right person under your prevailing law to assert the rights for a person. For instance, if your lamp is stolen from your house and you own that lamp, you have standing. If you're married and in your jurisdiction, a lamp in your house is a marital asset, then either spouse or both spouses together have standing. There's complicated issues as to incorporated entities as to when shareholders may have standing to assert a claim based on for a corporation. Here we have a fully unincorporated entity. It didn't register anywhere. And so the issue of who can act on its behalf is wide open. And finally, there are a lot of legal issues that remain unaddressed. And as the slide says, a lack of DR or dispute resolution is a tremendous problem. So why don't we just dive in and talk a little bit about the fine print here. I'm going to talk about the fine print that's available actually from 4 different sources. And this is problematic for anyone who's involved in contributing to the DAO who may be worried or concerned about what their rights are, because typically, at least in Western countries based on growing out of the British common law system, parties are held to the benefit of and burdens of their bargains. If you agree with someone that you're going to do something, you're going to be obligated to whatever you agreed to. That's just a general concept. And whether you look at them or not, you're going to be held, generally speaking, to the terms of your agreement. So in looking at the disclosures and disclaimers available to potential investors from various areas, it's important to understand what is going to be imputed against them, whether they saw them or not. And it's entirely possible, by the way, that a DAO token holder, or what I call an investor, has never seen any of this. They could have been told by a friend, if you send Ethereum to this address, you're going to get some tokens and you get to participate in the DAO. And they could have never looked at the code or at the marketing materials. It seems a little implausible, but it's not impossible. So enough about that. Let's talk about DAOhub.org. DAOhub.org was communicating information about the DAO up until and through the funding stage, and actually until right before the exploit occurred, without ever identifying who it was exactly that was speaking for the DAO Hub. So it wasn't clear to anyone looking at those materials whether this is officially on behalf of the DAO, on behalf of someone who's promoting the DAO. Is it the person who wrote the software? Is it Slockit? Is this something that's promoted by the Ethereum Foundation? It just wasn't clear. So enough of the sort of background here. Let's look at what the fine print actually said. You've got statements that appear to be geared toward investors, or the ones who want to make DAO tokens, and they suggest that its terms, as applied to the creation of DAO tokens, are secondary to that of what they call the DAO's code. And if you look at that first provision on the third line, it says the DAO's code. Now, there's no pointer to where that code is to be found, but it says also on the first and second line, the smart contract code existing on the Ethereum blockchain at 0xBB9 and so on. So I'm not even sure if that's the DAO code or if it's something else. But it says critically that the code is going to prevail if there's any conflict between what's on that website and what's found at the code. It says that these terms are for educational purposes and they don't supersede or modify the terms of the DAO's code set forth on the blockchain. So again, now I have a Ethereum blockchain address, a reference to the DAO's code, and something that says on the blockchain. It could be all the same or it could be different. I'm just not sure. And then it says that the code's going to control and cover all the terms. The next provision that I mentioned, or that I have on the slide, suggests that the smart contract code that governs the creation of DAO tokens can be found at an address, github.com/slockit/DAO. And it says that's the sole source for the terms under which tokens may be created. So maybe we have 4 different places to look for these terms, or they might all be the same. It's just not clear. And then finally, it says the third provision says by creating DAO tokens, you agree to all the terms and conditions set forth in that code. So that could all be the same, or a fifth, or this could just be sloppy drafting. It's really unclear. The final provision noted on this slide says that it's basically a warning of significant financial risk. It says that it's experimental software, that it's not a prospectus of any sort, it's not a solicitation for investment, and it doesn't pertain in any way to offering of securities. A lot of folks have asked, is this a security or not? And we're going to get to that. But it's relevant to note that here, this website is saying you're not making a security. It also talks about risk, and it picks up 3 significant categories of risk: security weaknesses in the software, weakness in the DAO's underlying blockchain or Ethereum, and the risk of unforeseen attack vectors. So from this website's perspective, there's warning. Then there's disclaimers of warranties and of the waiver of liability. So the warranties found on the DAO Hub website appear to be limited to creating the DAO tokens or creation only. Nothing here seems to suggest that it would apply to the operation of the DAO or the creation of any projects or splits, which is sort of interesting. The limitations waiver of liability here says that users of the DAO will not hold third parties or individuals associated with DAO creation liable, or for any injury caused by or related to the use of or inability to use DAO tokens or the DAO platform. So there do appear to be provisions, at least in DAOhub.org's statements, that would suggest that there's a waiver of liability. And it talks about liability due to the conduct of third parties including other creators of DAO tokens. So if you want to talk about the exploiter who used this recursion exploit, technically they would probably be viewed as a creator of DAO tokens, since you have to be a holder of DAO tokens to propose a proposal on the system. So there is an argument that could be made that there was a waiver of liability there. Now let's look at the GitHub. Okay. Now the GitHub is a place where the repository that contains the code for the DAO is held. Their disclaimer says it's a work in progress, that laws vary, that you're using this thing at your own risk. And here's a quote that I just love. One can only speculate about the legal status of DAOs worldwide. And I think that's actually really accurate. I'm not aware of any test cases. And it for the first time of what will be repeatedly suggests that users get legal advice. It says if you create a DAO, it will be your DAO and you'll be responsible. And that's kind of ironic because the creator of the DAO was Slockit. So based on their own language, it appears that they're responsible for the operation, notwithstanding that they created the code in that language. The next section down I think is really interesting. It says, contract as used in the code is a programming convention and not a legal contract. If you have questions about legal enforceability, get a lawyer. And I think just generally speaking, in any contract, that's a good idea. And then finally, the README file from which this is derived disclaims warranties, including the implied warranty of merchantability or fitness for purpose, and then it incorporates the GNU open source license. If you further down on the GitHub readme.md file, you've got disclaimers, and these are some of the most interesting. They disclaim being a lawyer. They disclaim giving any legal advice. They disclaim creating a legally binding contract in any jurisdiction or creating a attorney-client, they call it a lawyer-client, but attorney-client relationship. They say there's no privilege as to any communications. They say that distributing the software does not constitute legal advice. They say that if you use the software to provide legal advice, you may be subject to civil or criminal liability. That practicing law without a license may be a criminal violation of law. And to consult a lawyer in your jurisdiction if you have any questions about what or what does not constitute the practice of law. They say that they don't guarantee it meets the requirements of any particular legal system. And I think that's actually very prescient, because what they built does not really fit into any box very neatly. They say that for you to form a legally binding contract, you have to seek legal advice from an appropriately qualified and experienced lawyer in your jurisdiction. And then in little h on the slide, it says, issuance of DAO tokens may constitute the sale of securities in certain jurisdictions. And that kind of conflicts with what DAOhub.org says. And that's kind of interesting to me. So finally, let's look at the execution code. They also have disclaimers, and they have the same disclaimer of warranty and the same disclaimer of merchantability and fitness for purpose. And again, they incorporate the GNU license. So are any of these terms found in any of these three places enforceable against the investors? The answer is maybe. It's possible to invest in the DAO without seeing any of this. So it's unclear as to whether any investor has seen all of it or any of it or just some of it or none of it. However, as mentioned before, the law is going to impute that parties to agreements are aware of the agreements. Now, what about the waiver of any contract? You seem to see that throughout these materials. Courts will enforce knowing, intentional, and voluntary waivers. However, courts also will look at relationships and say, what's really going on here? So it's possible that a claim brought for breach of contract, where the narrative presented to the court is, I gave something of value for something else that I knew was a crowdfunding investment venture, and where I expected to have control over the investment, and somebody stole all of the value. Well, that's a compelling narrative. However, it could also be viewed as, based on the language that was provided, that sending Ethereum to a wallet resulted in you getting tokens that give you the right to do certain things, or perhaps the power as opposed to right to do certain things, and that you didn't have any actual claim on any of the value provided, nor that you had any assurances that the value would stay in there pending a vote. Ultimately, all of these all the different language that we looked at today says, go look at the code, read the code, see how it works, and that is exactly what you're binding yourself to. Notwithstanding the fact that it says there's no contract here, if you look at the code, it talks about how different parties are going to behave under different circumstances. And it looks like the exploiter here probably looked at the code a little bit closer than everybody, but perhaps Nick Szabo and Professor Gun Sirer. What that exploiter did is figure out how the system was going to operate under certain circumstances and use it that way. So who really violated the rights of the others here? It looks like perhaps the exploiter just did what the code was going to allow him or her or them to do. And it's kind of critical that nowhere in any of these disclosures or disclaimers is there a schematic layout of how this system is supposed to function, so to speak. It says in all of these different sources that the code prevails. So if there was an instance that said, for instance, a split always returns the contributed ether less the extra balance, in the event of a conflict with the code's going to govern. So in effect, the investors bound themselves to whatever the code was going to do. And in fact, here the code did something that was not expected. So let's take a deep dive into the legal issues here. I talked about standing, and standing generally is who is recognized under the law as having the ability to bring the claim. And pivotal to it is, are you the right person? Can you show that you were actually damaged? In this case, we have a complexity that's not typically foreseen because the DAO itself is not a legally incorporated entity. In this case, the DAO is a web of code attaching a bunch of persons who have the ability to act on that code by using certain powers provided by their DAO tokens. So what's critical here is that we have persons that are acting with respect to a res or an item, some property, but we don't have what we typically have in a business entity. Now let's talk about what incorporated business entities actually are, okay? Incorporated business entities are the consequence of a trade-off between individual actors and government. They exist as a consequence of legislatures passing laws that permit groups of individuals to take certain powers in exchange for giving up certain rights. Now, what do I mean by that? A business entity has the power to enter contracts on its own behalf using the fiction that it's an independent legal actor that's provided by the government. It also provides a group of actors to take on liabilities that will be the responsibility of the entity, not themselves. It provides what's called a corporate shield. In exchange, those individuals have to do something for the government. They have to disclose who they are in most jurisdictions. They have to file papers disclosing their activities. They have to pay money. They have to allow information about them to be public. They have to pay taxes. And they have to obey the legal system. You can sue an entity. Likewise, an entity can be a plaintiff bringing claims against someone else. And again, this is a trade-off. The government does this to allow people to run businesses. It fosters growth of the economy. Now, if you don't use a corporate form of some sort, in the DAO's case, like in the DAO's case, you find yourself being unsure who actually represents the DAO. It's an unanswered question and likely one that's without precedent. The two closest analogies would be an unincorporated association, and the example that's probably the most cited to in American law is the National Hockey League, or you can use a general partnership. Groups of people acting together for a joint purpose without incorporation are typically considered to create a general partnership. And let's talk about an unincorporated association first, using the NHL as an example. The NHL is a group of teams, the professional hockey teams, that work together to schedule and market together. But it's not an incorporated entity. There's no NHL that's registered with any government entity in the United States. The question for the analysis of who has standing to represent an unincorporated association is if there's a person who took an action on behalf of the entity, and it really becomes a control test. On the other hand, if you're looking at a general partnership, every participant is deemed a general partner, which means that they have total liability for all of the actions of the entity, which suggests in a conclusion that seems somewhat illogical, that every participant in the DAO can be fully responsible for its actions. Now, neither of these really fit. If you looked at the DAO as a general partnership and then applied that to Bitcoin, perhaps, you could find a situation where every node operator or miner or even wallet holder could be responsible for any activity of anybody using the system. And that just doesn't make sense. There's a gentleman named Pelly, I'm going to mess up this name, Brainguard, who wrote a really nice piece talking about how decentralized systems like Bitcoin don't need or necessarily have the corporate shield, but instead they use the shield of decentralization. And that is to say the system itself runs, and it's not under the control or guidance of any person. So the persons that may act with respect to it don't ultimately find themselves being viewed as those in control of the system. The system itself is in control of the system. So the standing issue, it requires an analysis of what is this thing and who can actually represent it structurally. If somebody wanted to sue the DAO, they would have to find a person who they think has standing to represent the DAO and serve them. So that's how most lawsuits work in most common law jurisdictions. What's the problem? Well, most of the actors here are actually anonymous because the investors or DAO token holders are transacting on pseudo-anonymous blockchains. If they don't want to be found, they're not going to be found. As far as the creators, well, we know that it's Slockit's code. So you can go ahead and try to sue folks in Germany. However, even determining who the actual creators are is something that's not so clear. When software is hosted on something like Git or GitHub, it can actually be updated by other participants. So in a hypothetical situation, not related to the DAO, but a different DAO, somebody could take the Slockit code, tweak it, deploy it. And if that person was anonymous, and the victims of some sort of fraud or exploit on the other DAO wanted to sue, they might point their fingers at Slockit and say, you wrote it. You wrote this functionality, it damaged me in some way, and now I'm going to sue you. But what they might find is Slockit might point to the functionality and say, I wrote the code, but this was changed, and it wasn't changed by me. So really, you're looking for whoever this anonymous person is that applied a commit to the code and changed it. So again, these issues aren't very clear. Then we have to talk about jurisdiction. Like I said, Slockit's in Germany. You don't know where people are. So it may be very, very difficult to bring them within the jurisdiction of your home court, so to speak. And you may find that you have to actually go out of your own jurisdiction to sue someone. This rapidly becomes very expensive, and for all but the most heavily invested DAO token holders, this may just render it a nullity or just something that they're not going to do. Then you want to talk about what kind of claims you could actually bring, assuming you could find somebody who stands for the DAO, and you're a DAO token holder who ostensibly lost some value in the DAO as far as the holdings, and who also lost value because their DAO tokens dropped in commercial price. So let's say for the time being that those are cognizable damages and you wanted to go ahead and try to sue somebody. Is there a contract anywhere? I kind of talked about it before. There looks like there are a number of different business relationships going on, happening here. But it's not clear as to whether any of these are contractual or sort of created by behavior. Now, courts will, under certain circumstances, impute contracts where parties acted as though they were in a contract. It's not entirely clear, to me at least, the circumstances, in these circumstances here, how a court would react. You've got persons acting like they're bound by terms. You've got express waivers of terms, but those waivers came in what are called contracts of adhesion, which means here are the contract terms, take it or leave it. And then finally, everything refers to code, which everybody was able to look at, and everybody could have, had they the sophistication to do so, looked at the code and seen, oh, this exploit's going to happen. So is there a legal contract? Maybe. The court might impute a contract. What are the terms going to be? More interesting question. So assuming that we have some sort of business relationship, And assuming that we have some sort of damage, whether, like I said, it's the drop in the value of the DAO tokens, or whether it's the diminution of the amount of Ethereum held by the DAO, who can sue who for what? Obviously, none of this is legal advice, and none of this should be understood as legal advice. The law varies from jurisdiction to jurisdiction. All of this is theoretical. These are brand new structures that have never been adjudicated before. So everything here is based on analysis. None of this is advice. So there are several theories that a party could try in order to state a claim. Like I said before, there may or may not be a contract. If there is a contract, there could be a breach of contract between the DAO token holders and the creators of the software, provided that there are representations in terms that indicated that the system was going to behave in a certain way, but that the system behaved in a different way. There could also be quasi-contract claims, which would assert that there was a contract created by behavior. There would also potentially be an unjust enrichment claim saying that other investor who exploited the DAO took more than they belonged, more than they should have. That other investor took more than they should have, and as a result, the other investors suffer. Now, it is unclear as to whether a contract will be found. If there is no contract, then contract theories are out the window, and then we have to look at tort theories. The most commonly thought of theory that might apply would be the criminal act of theft or the civil act of conversion. Now, to have theft or conversion, you have to have as a predicate ownership of something or the right to have possession of something. Now, the question of whether the DAO token holders have the right to possess the Ethereum that's held by the DAO is not so clear. The terms as they appeared suggested that DAO token holders gave Ethereum to the system and in exchange caused the creation of DAO tokens. I have yet to find a representation that says people who hold DAO tokens are entitled to get their Ethereum back. What I see is the suggestion that DAO token holders may operate a split, in that as a result of the split, they may receive back the Ethereum they contributed minus the extra balance. So if you want to say theft or conversion, the question is, does anybody own the Ethereum that's held in the wallet maintained by the DAO? The answer in my mind is as follows. Persons who hold DAO tokens have an expectation of returns, and so they think that they're going to benefit from that asset base. And I believe that they have a claim or a contingent claim upon the Ethereum that has been provided. The split allows them under certain circumstances to get some of their Ethereum back. However, if a totally legitimate project was funded and 100% of the Ethereum held went to some contractor, let's just say Drew's Mallet Factory, say that I proposed a proposal that suggested that I needed 200 million in US money equivalents to go build my mallet factory, and that I was going to repay that Ethereum with interest, and that everybody who holds a DAO token would in fact get a discount on my rubber mallets. There may be a situation where nobody can split. So it's not clear whether there's strict ownership. I consider it to be a contingent claim. So if you only have a contingent claim, it's not so clear as to whether there's been conversion or theft. Another theory that should be considered is the theory of tortious interference with business relationships. Now, that is a tort that suggests that a person has a business relationship with another entity or actor, and that something that someone else did interfered with the ability to enjoy that business relationship. They didn't have a privilege or an excuse for doing so, and that it resulted in damages to the person who was supposed to enjoy the contractual relationship. So the question of whether there's a relationship seems pretty clear. It may or may not be a contract, but there's some kind of relationship, and the person does have rights. Would the exploiter of the recursion bug or code error or code be viewed as having a privilege to do what they did, which is take more than they quote-unquote should have by splitting? The answer is not so clear. On one hand, every DAO token holder is allowed to split, provided that they have, I think it's 2 Ethereum worth of investment. So there's no problem with proposing a proposal A split is nothing but a proposal with one curator and one voter. So far, so good. Were they permitted to invoke the system in a way that returned more than their own Ethereum less their own extra balance? I'm not sure. It may be that the code prevails and the code behaved that way, so the code allows it. It may be that the code being drafted in error or against the spirit of other representations would be viewed as not governing, but then you have the more philosophical question of what governs here, the code or the intent? And that's perhaps for philosophers or perhaps for a later slide. Another potential claim here would be for a violation of the Computer Fraud and Abuse Act. Now that's a statutory claim provided under federal American law that punishes the unauthorized access to a computer system involved in interstate commerce. The Computer Fraud and Abuse Act, the key to that analysis is whether there's unauthorized access. Now it's unclear as to whether using a split to take more than the appropriate amount of Ethereum out would be considered unauthorized access. There's some case law that says it has to be beyond the scope of what was authorized initially, which we're okay. And then there's other circuits that say a Computer Fraud and Abuse Act claim will only lie if there wasn't authority to access before and there's unauthorized access. It's not clear whether taking the additional Ethereum would even be considered unauthorized access at all. So again, these are questionable. Big picture, if you've got a contract or if you can convince a finder of fact to find that a contract exists, you've got contract theories available to you. Otherwise, you have these equitable claims, which are tougher, and you've got tort theories, which are tougher, and you've got statutory theories, which, because this system is so new, are also tougher. Now, the bottom of the slide says, claims by the exploiter. Yes, the exploiter probably has some claims here. It has been suggested, and we're going to talk a little bit about it, that the Ethereum Foundation somehow has an obligation or is taking it upon themselves to fix this problem. The exploiter may credibly suggest that they used the DAO the way that the DAO was intended to be used, that because of the way the code was compiled and run, it resulted in their child DAO receiving more value than was contemplated by the marketing materials, but that the code governs. And as a result, their assets that they have are theirs. And any effort by anyone to actually prevent them from claiming their value would actually be considered tortious interference against them. So I know that a lot of folks are finding themselves with DAO tokens that have a diminished value, and they're very concerned about the ability to ever use the Ethereum that they contributed. And I know that folks facing losses of millions of dollars obviously do not like this analysis. However, following this analysis to its logical conclusion, if the code is the contract, and if the code permitted this, then the exploiter may be able to walk away clean. And if they do, and the Ethereum Foundation takes an action against them, they may actually have a cause of action for tortious interference, and may be able, even as implausible as this sounds, may even be able to get an injunction to prevent a fork or any sort of action to combat their exploit. So let's talk about those responses. The Ethereum Foundation, like I showed in that earlier slide, became aware of this issue at about 3:10 a.m. on Friday morning, Eastern Time. And within moments, the DAO Exploited was suggesting a couple different ideas. I'm going to talk about the soft fork and the hard fork idea. The hard fork idea suggests that the underlying blockchain upon which the DAO's contract code was operating would actually be modified to take the Ethereum in the Ethereum wallet of the exploiter and move it to a new wallet, which would be used to refund investors in the DAO, and that they would shut down the DAO. Slockit actually initially advocated for this approach, concluding that the DAO is closed, the DAO is over, and that this is the right approach. Other folks have argued that this approach is extremely dangerous. It, for one thing, would undermine the legitimacy of the Ethereum platform as an immutable ledger. It creates risk for the Ethereum Foundation, who could be viewed as having managerial or managerial control or managerial authority over the transfers, and that it would open the door for third parties like law enforcement to force transactions that were made ostensibly in a immutable ledger to be reversed. A lot of folks think that a hard fork would have significant risk. The second proposal was something called a soft fork. And what the soft fork would do is create code that would permit Ethereum's blockchain miners to selectively invalidate some transactions, and that the intention is that those miners would invalidate transactions made by the exploiter. And functionally what that would do is it would take the 50 million or whatever the market value is now, all of those exploited or taken Ethereum, it would take them off the chain, which means they wouldn't be spendable. This doesn't really provide any difference from the hard fork to the extent that it imputes control and potential liability upon the Ethereum Foundation. What it would actually do is permit the DAO to otherwise operate as long as its operations didn't implicate spending the Ethereum that was held in the DAO's wallet, because both the child DAO and the main DAO would be affected by this soft fork. This bothers me as well, and this worries me, because providing miners with the discretion as to which transaction they want to block also suggests a level of unpredictability as to which transactions may or may not be rolled back now or in the future. And the idea of the Ethereum Foundation getting involved in what to them should have appeared as an arm's length transaction is troubling, because it brings to question what the Ethereum Foundation is and what it's supposed to do. Is the Ethereum Foundation concerned with maintaining an immutable ledger? In that case, maybe it shouldn't be doing anything. Is the Ethereum Foundation concerned with making sure that its Solidity coding language works right? In that case, it should be investigating the exploit to determine whether it's a Slockit problem or whether it's an Ethereum Solidity problem. Or is this a Slockit problem, really? Did they make code that had problems? And as a result, should they be held liable? Having Ethereum get involved here suggests that the DAO is too big to fail. And that, again, as Peli Brandegard suggested, if the Ethereum Foundation does get involved, they are essentially abandoning their shield of decentralization, and they could be viewed as a control group against whom you could subpoena or try to have a court order executed against. Now, the Ethereum Foundation, and this is something that makes it different than Bitcoin, the Ethereum Foundation is actually a formally incorporated business entity. I believe it's incorporated in Switzerland. So it can already be served with process, although we obviously know Switzerland is a very favorable jurisdiction for avoiding such things. However, if Ethereum intervenes to roll back transactions, what is its role here? Why would it do this? Is it because the folks involved with the Ethereum Foundation are heavily invested in the DAO? Is it because it creates an optics issue for the DAO and for Ethereum? It's unknown, but there are certainly suggestions that there are some very, very interesting incentives at work here that may have motivated the Ethereum Foundation to offer these solutions. And of course, they can offer a hard fork and a soft fork if they want, and if the miners don't agree and don't adopt it, then it never comes into play. And so some have argued that takes responsibility away from the Ethereum Foundation. But when you have a centralized actor with the conflicts that they apparently do, I can't vouch for it, but they apparently do, it brings to mind the question, in what other circumstances will there be a fork? Does it have to be a $50 million failure? What about a $10 million failure? What about a failure that doesn't affect any members of the Ethereum Foundation? I'm only speculating as to their motivations here, but the conflicts of interest here create some problems. Slockit had a different response. They did nothing, and then they apologized and said they're doing the best they can. And then they acted. They actually initiated something that they call a white hat attack. And they were actually creating their own child DAO to suck all of the value out of the DAO before the exploiter's child DAO could get it. Seems like a nice idea. Problem. The exploiter then attacked the white hat DAO. And as many, including Professor Gunsirer, have suggested, this is silliness. This should stop. The attack and the counterattack and the white hat attack and the attack against the white hat attack, it's just on a certain level suggestive that the governance and the features of this system are not able to solve the problem, and that other means should be used to solve the problem. These are both terrible ideas for the reasons that I explained. The appearance that the Ethereum Foundation is actually acting as the system administrator for Slockit and for the DAO, and the appearance of these conflicts looks bad. The white hat attack, before it was attacked, looked interesting, but it seems very clear that there will continue to be a series of attacks and counterattacks, which suggests that this isn't really a great solution. So with apologies to Dr. Strangelove, Ethereum might want to stop worrying and start loving Mt. Gox. And what I mean by that is we might look at how Bitcoin handled the Mt. Gox explosion and say maybe they should try it. Mt. Gox was a tremendous loss event, and many, many people lost millions and millions of dollars. However, Bitcoin didn't crumble. It took hits. The media coverage was terrible. People lost a lot of money and are still incredibly unhappy about it. There's still litigation over it. But Bitcoin right now is as strong as ever. Its market valuation is up, up, up. And the system didn't take any action. The core developers didn't take any action to try to bail out those folks involved. They didn't try to roll back all those transactions. If Bitcoin survived, maybe Ethereum can too. So what are the lessons here? What can future providers of smart contract platforms, decentralized autonomous organizations, decentralized agents, and decentralized organizations, what can they learn here? The first thing is to ask, do I want an uncoercible system here? Is this the sort of activity that I want to work automatically based upon code where no one can intervene, except to perhaps create attacking code? Bitcoin works well because we're all used to a person-to-person transaction. I want to buy lemonade from the little girl down the street. I walk over, I hand her $1, and I get my lemonade. We're all used to one-way value transactions. Starting to build on top of that is admirable, and anybody who wants to should really look into Ian Griggs' 7-layer model for doing so. But when you get to some really complicated structures like the DAO is trying, you have to think about whether you want these things to be uncoercible and basically operate by the code. From a philosophical perspective, it looks great. But when you get unintended states with consequences like this, maybe you don't want an uncoercible system. If you're looking at the DAO and saying, what can we change to make it work? The answer is kind of everything. You want to change the technology. You may want to bake in some fail-safes. You're going to want to look at the software. You're going to want to look at the standards applied. And when I say standards, I mean quality checking standards. The governance system with respect to voting is very challenging. These systems have had a mixed track record with respect to getting participants to vote. So perhaps incentive systems that reward voting might work. This is why financial systems are heavily regulated. It's okay to play on the test net of these blockchains and deploy some code that creates unintended consequences. It's test net. It's no one's real money. When it becomes real money and things go sideways like they have, it's a problem. Governments work hard to make sure that their financial systems work right. And this is a perfect example of why similar development models and similar quality checking need to happen in these platforms. If you want to do it, test it, break it, test it, break it, test it, break it, give it to your friends, let them break it. You don't want to go live with something before it's ready. Preston Byrne said it, it's better to be correct than available. Don't rush to market and have a disaster on your hands as a result. And finally, as the lawyer, I say, have this thing interact with the legal system. I know that it goes against the concept of a fully autonomous organization that automatically effectuates its purpose and understands based on code everybody's respective rights. But one misplaced comma can really change the behavior. And whether it's legal or not, and whether the code is going to bind, or whether the intent is going to bind, whether the marketing materials are going to bind, this is a problem. What we saw is a big problem. And there has not been an adequate dispute resolution mechanism involved? Had there been an ombudsman that the investors could have all called and said, stop this is bad? I don't know how that would work. That would have to be thought about and determined. But if there was some sort of ombudsman that could have brought legal action, get a court order, and have your system not be uncoercible, that might have helped. You need to have the participants really understand what their legal rights are before they commit money to it. You may want to even incorporate it or have it be enforceable or coercible by an incorporated entity. The DAO was a fascinating experiment. Like Icarus, it flew very high very quickly and then had the same unfortunate result. Persons who wish to experiment in this space should look at this as an example that kind of cratered and did not go well. A lot of people will likely end up losing a lot of money on it. This isn't fail fast and fail hard. This is kind of a disaster, but it does not sound the death knell of this technology or of these concepts. I firmly believe that smart contracts built on top of blockchains can accomplish a lot. I think that in the coming years, there will be a lot of innovation. I think that the DAO was very, very aggressive, was possibly released a little bit too early, and had some really unfortunate results. There's a lot of runway between what we see now in Bitcoin and what we see Slockit trying to accomplish with the DAO. So thank you for joining me this evening. I hope that everybody enjoyed it. I apologize that I couldn't speak to you in person. This is my contact information if you have any questions, and all my thanks to the OnChain Scaling Conference for providing me this opportunity to chat with everybody tonight. Thanks a lot. Take care.